The House will come to order. Members will be at their seats. The clerk has opened the roll. We may record your presence. Please rise and give your attention to our House chaplain and remain standing for the Pledge of Allegiance, led by Representative Stocksdale.
Shall we pray? Almighty God, we thank you for this beautiful day, a day closer to spring. This turnaround week is going to be a busy week. Be with each of our leaders throughout all of the discussion, debate, and final action. Renew their minds individually and collectively. Help them to not be conformed to divisive patterns, but transformed by your grace. Help them to not think so highly of themselves that they fail to be reasonable and use careful judgment. Remind them to discern your will, that which is good, pleasing, and right. In your name I pray, amen.
Have all members had the opportunity to record their presence? The clerk will close the roll and record the attendance.
Oh, yes. Yeah. No. Oh, gotcha. Susan Ruiz is here also.
Introduction of bills and concurrent resolutions. The clerk will read.
House Bill number 2425 by the Committee on Appropriations. An act concerning higher education, requiring a member of the State Board of Regents to be a student member, creating procedures for nomination, appointment, and confirmation, establishing the term of office, relating to duties of the Students' Advisory Committee.
Speaker recognizes the Majority Leader for a motion to accede.
Thank you, Mr. Speaker. The Senate did not concur in the House amendments to Senate Bill 29. I move the House accede to the request of the Senate and that a conference committee be appointed.
You've heard the motion. All in favor signify by saying aye. Opposed, no. Motion passes. A conferees on the part of the House, the chair appoints Representatives Johnson, Croft, and Neighbor. Speaker recognizes the Majority Leader for a motion to accede.
Thank you, Mr. Speaker. The Senate did not concur in the House amendments to Senate Bill 39. I move the House accede to the request of the Senate and that a conference committee be appointed.
You've heard the motion. All in favor signify by saying aye. All opposed, no. Motion passes. As conferees as part of the House, the chair appoints Representative Rogers, Eric Smith, and Carlin. Speaker recognizes Majority Leader for motion to accede.
Thank you, Mr. Speaker. The Senate did not concur in the House amendments to Senate Bill 40. I move the House accede to the request of the Senate and that a conference committee be appointed.
You've heard the motion. All in favor signify by saying aye. Opposed, no. Motion passes. As conferees on the part of the House, the chair appoints Representative Rogers, Eric Smith, and Carlin. House Bill 2262 appears on the consent calendar for the second day. Is there objection? Seeing none, it will remain on the consent calendar for the third day. House Bill 2275 appears on the consent calendar for the second day. Is there objection? Seeing none, it will remain on the consent calendar for the third day. House Bill 2292 appears on the consent calendar for the second day. Is there objection? Seeing none, it will appear on the consent calendar for the third day. House Bill 2355 appears on the consent calendar for the second day. Is there objection? Seeing none, it will remain on the consent calendar for the third day. House Bill 2390 appears on the consent calendar for the second day. Is there objection? Seeing none, it will remain on the consent calendar for the third day. The chair recognizes the majority leader for a motion to resolve into the committee of the whole.
Thank you, Mr. Speaker. I move the House resolve itself into the Committee of the Whole for the purpose of considering those items under the heading of General Orders.
You've heard the motion. All in favor signify by saying aye. Opposed, no. The ayes have it. The motion carries. The chair appoints Representative Highland to chair the Committee of the Whole.
Good morning, everyone. First item of business is House Bill 2212. For the purpose of carrying House Bill 2212, Chair recognizes Representative Aricamp.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. House Bill 2212 makes 4 changes to the Kansas alcohol license laws. The main one is that it removes any residency requirements throughout the Liquor Control Act, the Club and Drinking Establishment Act, and the Cereal Malt Beverage Act. It also requires the appointment of an agent who is a Kansas resident if the applicant is not a Kansas resident. It changes shall to may for the director's duty to perform certain background checks for out-of-state applicants, and it removes the requirement for an out-of-state corporation to domesticate their business in order to receive a Kansas license. Currently, in order to receive a license, Kansas law requires an applicant to be a resident of the state of Kansas and, in some circumstances, a resident for a certain amount of time. Recently, the United States Supreme Court ruled that these types of residency requirements were unconstitutional and violated the Dormant Commerce Clause by favoring in-state over out-of-state interests with no justifying legitimate purpose. The bill was requested by the Kansas ABC director in order to make Kansas laws align with a recent U.S. Supreme Court case. In her testimony, she stated that without this change, the Kansas ABC could be sued in 2 ways. One, if an application is denied because of non-residency, and the other is if the ABC does not enforce the residency requirements of our state law and issues a license to non-residents. The Kansas Attorney General also offered an opinion last December and stated that Kansas residency laws would likely be found unconstitutional if challenged. This bill eliminates the conflict and aligns Kansas alcohol license laws with the current recent Supreme Court ruling. Mr. Chairman, happily stand for questions.
Thank you. Does any member wish to speak to the bill? The chair recognizes Representative Ruiz Lewis.
Thank you, Mr. Chairman. This bill was kind of a complicated, non-complicated bill brought to us by a Supreme Court decision in Tennessee on the Supreme Court to allow residency in the state of Kansas and others across the United States to make it conform. So I urge your support. The representative did a great job of explaining the bill, pretty thorough. So again, I do urge your support. Thank you, Mr. Chair.
If there is no further discussion, Representative Arkamp, you may close.
Thank you, Mr. Chairman. I move that when the committee rises and reports, it reports House Bill 2212 favorably for passage.
You've heard the motion by Representative Arkamp to report House Bill 2212 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2321. For the purpose of carrying House Bill 2321, the chair recognizes Representative Delperdang.
Thank you, Mr. Chair. There were two committee amendments on House Bill 2321, so I move the adoption of the committee report.
You've heard the motion. All in favor signify by saying aye. Opposed, nay. Motion passes and the committee report is adopted. You may continue.
Thank you, Mr. Chair. Last year, we had a bill presented for electric vehicles charging stations. During that presentation, there was an amendment submitted.
Let's keep it to a dull roar, please.
Thank you, Mr. Chair. Let me start over here. Last year, we had a bill presented for electric vehicle charging stations. During that presentation, there was an amendment submitted concerning electric transmission lines and poles in the northeast community of Wichita. I stood up for that amendment and I spoke to the body concerning EMR, also known as electromagnetic radiation, that is possible with these high voltage transmission lines, which are constructed a little bit differently from normal distribution lines that you typically see in neighborhoods. That bill passed overall, but it died due to COVID. Well, HB 2321 is no longer an amendment of another bill, but rather a standalone bill worthy of its own merits. This bill prohibits the construction of urban electric transmission lines with voltages greater than 69,000 volts, but less than 230,000 volts. Keep in mind, transmission lines that are greater than 230 kV are currently regulated by the KCC. The bill also prohibits electric utilities from exercising the right of eminent domain to acquire interest in land in connection with those actions before the utility provides notice of preliminary plans to the city in which the lines would be constructed. This bill specifies requirements for the official notice and authorizes the governing body of any city with a population of over 300,000 to exercise zoning and siting jurisdiction over the line construction. The bill also defines electric utility and urban transmission lines. With that, Mr. Chair, I will stand for questions.
Does any member wish to speak to the bill? The chair recognizes Representative Finney.
Good morning, everyone. All of you may remember, particularly those that have been here for a while, when I got up a few times and I talked about those, what we call jokingly BAPs, those big old poles that were placed in the northeast community in Wichita, Kansas. And for those who are new, you may not know about this, but you've probably seen it in the media because there was a lot of publicity about this. This bill today addresses that bill. And what it does, it gives notification to the community, and that is something that we didn't have before when those poles were, those transmission lines were placed in northeast Wichita. This bill also expands on giving notification to a government entity like our city of Wichita that would give them a 6 months advance notice and an opportunity to review the plans. In addition to that, it offers an opportunity for the landowners and people that are directly impacted to be able to have public comment regarding it. That is something that we didn't have before. This bill gives us an opportunity for the city to have input on it, and it gives opportunity for the landowners and tenants that previously didn't have an opportunity to speak. It gives them an opportunity to speak. In addition to that, it requires a notification within the local newspaper when such a major construction is going on. This bill has been called the urban electric transmission line. It will be 2.5 miles in length, and the project in Wichita was 3.1 miles for those who don't know. And it will go through 2.5 continuous miles through the city and at least 300,000 people. The reason I want to stand up and speak about this bill is because those who know me, they know I was very, very, very passionate about this bill. I felt that it impacted our community, it disrespected our community, and that people had to live with this continuously. But one of the things that happened that I'm very proud of that doesn't always happen, we had different Zoom meetings with the company, Evergy, for those who don't know. Myself and several other community members, we came together and we met with Evergy one-on-one, with Evergy and their different executives, and we told them the things that we would like to see happen. I have to give Evergy credit where credit is due. They took the time. It took us over 2 months to negotiate this bill that you see in front of us. Sometimes you feel like a monopoly company, they don't listen to you. At the time, we felt like that. So we were very glad, particularly myself, Councilman Brandon Johnson in Wichita, Kansas, and we also sought the legal advice from the City of Wichita legal department. And we also ran this by the city manager in Wichita. So again, this is a bill that was negotiated between our community and members that it directly impacted. And it is something that we thought it was a give and take on both ends. I ask for your support of this bill today, and I ask for support of this bill in the draft that it is. Make it a bill that without amendments if possible. Because I think it is fair, and I think the company has taken the time to at least address this issue, and I support it, and I ask for your support as well. Thank you for your time.
For further discussion on the bill, the chair recognizes Representative Keither. And when you come up to speak, if you would speak right into either the right-hand mic or get closer. People are having trouble hearing.
I got to get it down low enough, too. I rise in support of this bill. This bill represents what every single one of us are here to do. This is a state representative doing something for her community that she has been asked to do and has worked hard for at least, 3 years to get this passed. This is a personal agreement between the state representative and her district where the damage was done. And this is something that she's worked hard on and we need to support her agreement and support her community because that's what she's up here doing. She's doing her job. So with that, Mr. Chairman, I support House Bill 2321. Thank you.
Thank you. For further discussion, the chair recognizes Representative Carmichael.
Thank you, Mr. Chairman. Without yielding the floor, I initially rise to a point of parliamentary inquiry. I hear there may be a birthday boy in the chair.
That time has passed.
The chair is wise. Thank you, Mr. Chairman, to address this legislation on its merits. What happened in 67214, a predominantly African American area of the city of Wichita, is absolutely abominable. You wouldn't want to have it happen in your neighborhood. You wouldn't want to have it happen to your neighbor. The fact of the matter is that a for-profit electric utility destroyed the neighborhood. They did it over 3 years ago with over 100-foot power poles that they literally put in people's front yards. 100 foot in the air, 6 to 12 foot wide, put it in somebody's front yard. Now, they did that because they have the power of eminent domain. They, the for-profit electric utility, has the power and the authority to take your land for its profit. And that's exactly what they did. They also took their existing right-of-way, misled the neighborhood, said we're replacing the poles, we're going to put better poles up, and they put 100-foot towers in the existing right-of-way. The original version, let me also mention that in the 3 years that my good friend from Wichita has been working on this legislation, we've heard promise after promise from the for-profit electric utility known as Evergy that they were going to make it right. I drove through the neighborhood yesterday. They haven't made it right. They've done a little bit here, a little bit there, but it's still destroyed. What have the neighbors got for it? They got an open house and a milk and cookie party. Literally a milk and cookie party, where Evergy said they would listen, but then they didn't do anything. The original version of this bill would have protected your constituents, my property rights, and your property rights. It would have said that when the for-profit electric utility wants to put up a line of between 69 kilovolts and 230 kilovolts, and that's the type of lines in question here, and if it was more than 2.5 miles in length, that there would be supervisory authority on the private for-profit utilities' exercise of eminent domain, and that supervision would have been exercised by the city council in cities of over 300,000. Nothing could be more important for local control than allowing city council members to stop for-profit utilities from putting 100-foot poles in people's front yards. But that's not the bill we have before us today. The utility instead came back with a compromise. What is the compromise? The compromise is a milk and cookies open house sponsored by the utility, where they will pay for the milk, they will pay for the cookies, they'll invite somebody from the KCC to sit and listen, and then they'll go ahead and do the same thing to your neighborhood that they did to the representative from Wichita's neighborhood. Now, I hold in my hand an amendment that would take this bill back to the meaningful amendment which the representative introduced. I have no illusions as to what the fate of such an amendment would be, because what the utility wants you to do is pass meaningless legislation, claim a victory, and move on down the road. So, our options are to amend the bill to make it mean something, to vote no because the bill is meaningless and will only encourage more bad behavior by this particular utility, which is now under domination by a hedge fund known as Elliott Management, associates of which made over $71 million on their investment just last week which would have been more than enough money to fix what's wrong in the representative's neighborhood, but they didn't spend it that way. Or to vote aye and go home and claim that we've done something about it when we haven't. I'm not going to offer the amendment. I don't think it would pass. It will just take up more time today, and it will make members take a difficult vote that they would have a hard time explaining to their constituents when they got home. So as for me, I'll simply vote no today, not because I disrespect the work of the representative in trying to help her neighborhood, but because passing meaningless legislation in this circumstance will only encourage further bad behavior by a company which is becoming dominated by a hedge fund which wants to increase shareholder return at the expense of ratepayers and neighborhoods like 67214. So, Mr. Chairman, I oppose HB 2321. Run out of oxygen in a mask some days. Thank you very much, folks.
Seeing no further discussion, Representative Delperdang, you may close.
Thank you, Mr. Chair. And I
Back off, please. Just a moment. Somebody pushed their button. I'm sorry. For further discussion, the chair recognizes late. No, he's been waved off. Okay. Representative Delperdang, go right ahead. Sorry about that.
Thank you, Mr. Chair. I appreciate everybody coming up here and speaking to it. And it is something that needs to happen. This needs to go through for Kansas. I personally have gone out and toured through the neighborhood with these poles in there. Like the previous speaker, they're atrocious. They are just discerning to the neighborhood, and I'm even concerned from a public safety perspective. And if we can do anything to help prevent this in the future, I am all there for it. So, body, I ask your support on this thing. It is a good bill overall. It was a compromising bill between the power utilities and the original maker of the bill. So, Mr. Chair, I move when the committee rises and reports that it reports HB 2321 favorably for passage. Thank you.
You've heard the motion by Representative Delperdang to report House Bill 2321 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2297. For the purpose of carrying House Bill 2297, the chair recognizes Representative Anderson.
Thank you, Mr. Chair. There were no committee amendments. HB 2297 is a housekeeping bill. This bill was introduced last session. It passed the Senate 38-2 and was scheduled for a House consideration until early adjournment. This bill allows the Secretary of State to move forward on modernizing the publication responsibilities of the office and to provide additional publication offerings. There were 6 proponents to this bill and no opponents. First, the bill standardizes pricing mechanisms for publishing, storing, selling, and distributing the publications. Second, it allows the office to follow the state procurement process to seek additional bids from third-party printers. Third, the bill will allow for electronic subscriptions to the Kansas Legislature. And lastly, this bill would update state statute on required notices of amendments to the Kansas Constitution. There is a fiscal note associated with HB 2297. The agency expects to lose approximately $35,000 annually on these publications, but with the enactment of HB 2297, this would allow the agency to recoup the cost of production and shipping, which would result in savings to the agency of nearly $35,000 in FY 2021 and $35,000 in FY 2022. This savings is based on the difference between the prices set by current regulation and the prices that would be set based on actual cost authorized by the enactment of this bill. And with that, I will stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Clayton.
Thank you, Mr. Chair. The previous speaker did a good job describing the content of this bill. I do want to let those of you who might have state employees in your districts know that the impact on this should be fairly minimal, although it does allow the state to outsource printing. I don't think that it will cause any major harm due to the folks that I have consulted with. So I urge your support. Thank you very much, Mr. Speaker.
Any further discussion on the bill? Seeing none. Representative Anderson, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it report House Bill 2297 favorably for passage.
You've heard the motion by Representative Anderson to report House Bill 2297 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. The next item of business is Senate Bill 33. For the purpose of carrying Senate Bill 33, the chair recognizes Representative Sywert.
Thank you. Thank you, Mr. Speaker. I don't normally come down here too much, so I'm going to make this short and brief. Senate Bill 33, there was no committee amendments. It is basically relating to Vehicle Dealer and Manufacturer Licensing Act, providing for display show license plates, allowing for new vehicle dealers and manufacturers to participate in this display. What that means, when they have a new vehicle introduction, they can go to this, they buy a permit, gives them a temporary tag, and it's only for new dealers and new dealer entries in the certain geographic locations. There were no committee amendments. There were also no floor opponents or neutral or opposition. So with that, I move 33 for favorable for passage.
Not yet.
I will stand for questions at the appropriate time.
Does any member desire to speak to the bill? The chair recognizes Representative Helgerson.
I just wanted to say I'm in support of the bill and look forward to great cooperation between both parties on this bill and others.
Any further discussion? Seeing none. Representative Sywert, you may close.
Thank you, Mr. Leader. I move favorable passage for Senate Bill 33.
You've heard the motion by Representative Sywert to report Senate Bill 33 favorably. All those in favor signify by saying aye. All opposed, nay. It appears the ayes have it. The ayes do have it. Motion passes. Next order of business is House Bill 2367. For the purpose of carrying House Bill 2367, the chair recognizes Representative Samso.
Thank you, Mr. Chair. HB 2367 comes from the committee, House Energy, Utilities, and Telecommunications. We'll make this brief. The passage of this bill is intended and will help benefit the safety of the public throughout Kansas. We had a number of proponents. There was a teaching moment involved that before you bring your bill to the legislature, make sure everyone's made their phone calls and done their homework first. We had one snafu, but we were able to get that resolved. There were no opponents to the bill. I know everyone's read it already, so I will stand for any questions, Mr. Chair.
Does anyone desire to speak to the bill?
And there were no committee amendments. I think I forgot to mention that, Mr. Chair.
No, you did. The chair recognizes Representative Keither.
Thank you, Mr. Speaker. I do believe that this is a necessary bill to bring the wire stringing issue to the same level as requiring safety requirements on a national level. The KCC member, Leo Hanos, who's been there forever, came in and testified that this was necessary. The information that they want to understand where everything is and how it works is available without any piece of legislation. But I will go ahead and support it. I think it could have been handled in a different way with people cooperating and talking to one another before they brought it to a piece of legislation. But I think considering it's a public safety issue, I think we need to go forward with it. Thank you, Mr. Chair.
Is there further discussion? Seeing none, Representative Sampson, you may close.
Thank you, Mr. Chair. It's a good bill. Urge your support. I move that when the committee rises and reports, it reports HB 2367 favorably for passage.
You've heard the motion by Representative Sampson to report House Bill 2367 favorably. All those in favor signify by saying aye. All opposed, no. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2137. For the purpose of carrying House Bill 2137, the chair recognizes Representative Penn.
Thank you, Mr. Chair. There were no committee amendments. I rise before the body to present House Bill 2137, an act authorizing certain licensees under the Kansas Liquor Control Act and the Club and Drinking Establishment Act to sell and serve cereal malt beverages. There were no opponents. In short, 2337 is a cleanup bill from the 2017 legislation that was passed, commonly known as Uncork. House Bill 2137 allows a Class A and B club drinking establishments, temporary permit holders, and caterers to sell and serve cereal malt beverages called CMB without obtaining a local CMB license. House Bill 2137 allows retail liquor stores with wholesalers' permits to sell CMB to restaurants just as they sell wine and beer to drinking establishments. CMB is defined in the CMB Act as those drinks having not more than 3.2% alcohol by weight and produced by fermentation and not by distillation. This definition means that many low-calorie, low-alcohol content beer products fall under the statutory definition of CMB. House Bill 2137 also allows the consumption of CMB in common consumption areas. Proponent testimony for this bill was provided by Tuck Duncan of Kansas Wine and Spirits Wholesalers Association, Amy Campbell of the Kansas Association of Beverage Retailers, Jason Watkins of the Kansas Beer Wholesalers Association, and Scott Schneider of the Kansas Restaurant and Hospitality Association. Neutral testimony for this bill was provided by the Director of the Alcoholic Beverage Control Division, Ms. Debbie Beavers, and the fiscal note shows that this bill, as introduced, would have no fiscal effect on CMB or liquor tax revenue. With that, Mr. Chair, I will stand for questions happily.
Does any member desire to speak to the bill? The chair recognizes Representative Kessler.
Thank you, Mr. Chair. Body, this is a good bill. This bill is brought to us today because of an oversight when we changed our strong beer laws a couple of years ago. It's a cleanup bill, but it's also a great testament as to why we should never change liquor laws with amendments. Because like this bill, even though it had committee hearings, it's still proof of how difficult it can be to get it right. This is a good bill, and with that, I do fully support this bill and urge you to do this as well. Thank you, Mr. Chair.
Thank you. For further discussion, the chair recognizes Representative Reese.
Thank you, Mr. Chairman. The representative did a good job of explaining the bill and what the processes were to bring this bill to fruition. I urge your support, and thank you, Mr. Chairman.
For further discussion, the chair recognizes Representative Williams.
Thank you, Mr. Chair. I have an amendment pertaining to cocktails to go.
Amendment appears long. Would you explain, please?
Sure, I would be happy to explain the amendment. The amendment would allow for open or closed original containers of beer and wine. It does extend the sunset or eliminates the sunset that we actually postponed on June 3rd with House Bill 2016 and on January 21st through Senate Bill 14. It also maintains our current liquor by the drink laws. and it does also require that if the container is taken curbside or to go, that it be placed in a transparent bag with the receipt visible. And they would not be allowed to serve curbside or carry out after 11 p.m.
Have you finished your explanation?
Yes, I will stand for question. Yes, I.
Thank you. Is there objection to waiving the reading of the amendment? There is objection. The clerk will read.
Page 21, by striking all lines 7 through 43. On page 22, by striking all lines 1 through 7. Following line 7 by inserting section 19, KSA 2020 sub 41 2653 is hereby amended to read as follows. A, in addition to the rights of a licensee pursuant to provisions of KSA 412637 and amendments thereto, a Class A club license, Class B club license, or drinking establishment license shall allow the licensee to allow legal patrons of the club or drinking establishment to remove from the licensed premises one or more open containers of alcohol, liquor, or cereal malt beverage subject to the following conditions. Number 1, must be legal for the licensee to sell the alcoholic liquor or cereal malt beverage in its original container. Number 2, alcoholic liquor or cereal malt beverage must be in its original container. Number 3, each container of alcoholic liquor or cereal malt beverage must have been purchased by a patron, and the alcoholic liquor or cereal malt beverage in each container must have been partially consumed on the licensed premises. Number 4, the licensee or licensee's employee must provide the patron with a dated receipt for the unfinished container or containers of alcoholic liquor or cereal malt beverage. Number 5, before the container of alcoholic liquor or cereal malt beverage is removed from the licensed premises, the licensee or the licensee's employee must securely reseal each container, place the container in a tamper-proof transparent bag that is sealed in a manner that makes it visibly apparent if the bag is subsequently tampered with or opened. B, number 1, in addition to the rights of a licensee pursuant to provisions KSA 412637-42 and amendments thereto, and the provisions of subsection A Class A club license, Class B club license, or drinking establishment license shall allow the licensee to allow legal patrons of the club or drinking establishment to remove from the licensed premises one or more containers of alcoholic liquor or cereal malt beverage that is not in the original container or is in the original unopened container, subject to the following conditions. A, it must be legal for the licensee to sell the alcoholic liquor or cereal malt beverage. B, each container of alcoholic liquor or cereal malt beverage must have been purchased.
The objection is lifted. Do you have further explanation?
Yes, I do. Thank you, Mr. Chair. Briefly, my amendment today would remove the sunset on cocktails to go. This permanent change will create certainty and continue to be helpful for many restaurateurs. This reform would allow those restaurateurs, those business owners, to put dollars back in their pocket by simply streamlining the law. So I'll stand for questions.
Does any member wish to speak to the amendment? The chair recognizes Representative Kessler.
Thank you, Mr. Chair. Because of my previous statement on this bill, I think it's important to clarify that this amendment is basically allowing restaurants to continue to do the carry-out curbside alcohol sales as they are currently allowed under the pandemic emergency, and do this on a permanent basis. Although I would have liked to have seen some sort of food sales requirement on this, I do support this bill in the name of helping the restaurants and the hospitality industry. Thank you, Mr. Chair.
For further discussion, the chair recognizes Representative Barker.
Thank you, Mr. Chair. This is a friendly amendment. It did not get to us in Fed and State prior to working this bill. And this just continues existing law. The only change is now they do not have to uncork the bottle and they can still sell it to you, and you can take it with you. As you know, when we passed the bill during the emergency, that you had to have the bottle open. If, for example, instead of drinking the entire bottle of wine, you could take a half a bottle. They would seal it in a clear plastic bag, and you could take it with you. This is a continuation of that. I stand today in support of the amendment. Thank you, Mr. Chair.
For further discussion, the chair recognizes Representative Clayton.
Thank you, Mr. Chair. I echo the support as well. While it is unfortunate that we did not get the opportunity to give this a full hearing in committee, I stand in support of this because I do feel that it would be very beneficial to the numerous hospitality industries in my legislative district, which borders Missouri. I will obviously leave this up to the will of the body, but wanted to let you know about that. Thank you, Mr. Chair.
Seeing no further discussion, Representative Williams, you may close.
All right, thank you, body, and thank you, Mr. Chair. Since the onset of the pandemic, our restaurants have had to recreate how they operate with changes to allowable seating, social distancing, PPE, closing times, capacity, and even complete closure. It is estimated that 1 in 6 restaurants will never reopen due to the pandemic or our response to the pandemic. It is also estimated that total food and drink for hospitality sales from January 2020 to January 2021 are down 23%. Today's amendment provides a little relief to those businesses as their carryout sales continue to make up a larger percentage. This amendment also eliminates unnecessary regulation on the restaurant and bar industries as well as their customers. In the past 9 months, the allowance of curbside and carryout of alcoholic drinks has proved both popular and convenient, successful, and safe. Considering these items, I ask you, the body, to join me in supporting this amendment and to make permanent curbside and carryout alcohol. I close on my amendment to HB 2137. Thank you, Mr. Chair.
You've heard the motion by Representative Williams to amend. All those in favor signify by saying aye. Aye. All opposed, no. The ayes appear to have it. Division has been called. Open the roll. Every member had the opportunity to vote. Hubert, Representative Hubert votes aye. Representative Newland votes aye. Representative Ellis votes aye. No further?
Yeah. It's not a roll call, so.
Seeing no further changes or the roll, close the roll. 105 voting in favor, 8 against. The motion passes. The bill is amended. Back on the bill. Anyone else wishing to speak to the bill? Seeing none, Representative Penn, you may close.
Thank you, Mr. Chairman. COVID-19 has had a devastating impact on businesses in Kansas, and our business owners, workers, and are demanding our engagement and our help. With a favorable vote on this bill, we have the opportunity to lessen the burden of unnecessary regulation, unleash some of our business community's potential, while also helping businesses and families throughout the state recoup a little of the hope that COVID-19 stole. So, Mr. Chair, with that, I move that the committee rises and reports that when the committee rises and reports, it reports House Bill 2137 as amended favorably for passage.
Thank you. You have heard the motion by Representative Penn to report House Bill 2137 as amended favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2201. For the purpose of carrying House Bill 2201, the chair recognizes Representative Proctor.
Thank you, Mr. Chair. There were committee amendments. I move the adoption of the committee report.
You've heard the motion. All of those in favor signify by saying aye.
Aye.
All opposed, no. The motion passes and the committee report is adopted. Please continue.
Thank you, Mr. Chair. I rise before the body to present House Bill 2201. The purpose of this bill is to give the Secretary of Transportation the maximum flexibility to find and use federal stimulus dollars for transportation infrastructure projects here in Kansas. Current law requires at least one phase of each modernization or expansion project selected for construction during T-Works to be let before any of the new Eisenhower program, the Ike program, modernization or expansion projects is let to construction. This bill would allow the Secretary of Transportation to go ahead and let to construction a modernization or expansion project under the new Eisenhower program if that program would utilize federal stimulus funds and none of the remaining T-Works modernization and expansion projects qualify for the funds. This bill would also exempt the Secretary from the maximum debt limitations on the issuance of bonds under T-Works or the Eisenhower program when the bonds are for the purpose of refunding. And finally, the bill would reduce the minimum cost for a project for which alternative delivery procurement methods could be used from $100 million to $10 million. Proponents of the bill included the Secretary of Transportation, the Kansas Contractors Association, the South Central Kansas Transportation Coalition, Kansas Good Roads, the League of Kansas Municipalities, and the Wichita Regional Chamber of Commerce. There were no opponents. Thank you, Mr. Chair. I'll stand for questions.
Does any member wish to speak to the bill? Never seen this before. Seeing none. Representative Proctor, you may close.
Thank you, Mr. Chair. I move that when the body rises to report, it reports House Bill 2201 favorably for passage.
You've heard the motion by Representative Proctor to report House Bill 2201 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The motion passes. Next item of business is House Bill 2203. For the purpose of carrying House Bill 2203, the chair recognizes Representative Lee Hahn.
Good afternoon. Mr. Chair, there were no amendments, and I move the adoption of the committee report.
There were no amendments. There is no committee report to report, so please proceed.
Ron? HB 2203 would allow penalties and fees collected for the asbestos program to continue to be remitted to the Asbestos Remediation Fund rather than the State General Fund beginning in fiscal year 2022. Proponents of this bill are KDHE, Kansas Grain and Feed, Kansas Agribusiness Retailers Association, Renew Kansas Biofuels Association, Kansas Electronic Cooperatives, and a few others. There were no neutrals, no opponents. Thank you, Mr. Chair. I'll stand for questions.
Does any member desire to speak to the bill? Oh, we've got quite a list. The chair recognizes Representative Arnberger.
Thank you, Mr. Chair. Representative, will you stand for questions? Thank you. First, do you know of any state buildings that have asbestos?
No, I do not.
Well, Representative, have you heard of the docking building?
I sure have. I think we need to sell that dude and get some cash coming in.
Well, Representative, would you find it, I have an amendment, would you find it a friendly amendment to take the fees from this bill, which is what, roughly $87,000? $85,000, create a docking building savings account asbestos fund, and then we can take that money from there and go ahead and start on the asbestos removal, which has been a lot of talk because we can't do anything. And then I think roughly it's about $100 to $150 million. So I think it might take a couple years to get to there. Would you call that a friendly amendment?
Will it cover the cost? Will that cover the cost?
Yes.
The majority leader wouldn't agree with you.
Representative, is this your first bill? Yep. Welcome to the legislature.
Thank you.
For further discussion, the chair recognizes Representative Corbett.
Thank you. I think the representative did a great job, and I urge your support. Thank you.
For further discussion, the chair recognizes Representative Carlin.
Thank you, Mr. Chair. I actually will support the bill, but I do want to point out that, again, we are transferring money from the State General Fund into another fund. In this case, it goes to the State Treasurer's Office. My first bill analysis for my side here, I showed no fiscal impact, but I checked, and there is a fiscal impact for 2022 of $25,000 in just this fee fund. And it is, the balance of that, of course, is going to, the way it's written about 1 year, $110,000 collected, $85,000 budgeted, the rest, whatever. But that fund would fluctuate from year to year. So I don't know how that goes for another year. But I do think it's a good thing that we have a fund to take care of abatement and that people can do the work and get repaid. So I will support the bill. Thank you, Mr. Chair.
Seeing no further discussion, Representative Lehon, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports HB 2203 favorably for passage.
You've heard the motion by Representative Lehon to report 2203 favorably. All those in favor signify by saying aye. Aye. All opposed, no. The ayes appear to have it. The ayes do have it. The motion passes. The next item of business is House Bill 2387. For the purpose of carrying House Bill 2387, the chair recognizes Representative Ralph.
Thank you, Mr. Chair. There were committee amendments. I'd move the committee report.
You've heard the motion. All in favor signify by saying aye. Opposed, no. Motion passes. You may continue.
Thank you, Mr. Chair. The House Bill 2387 was introduced by the Judicial Council's DUI Advisory Committee. That advisory committee has been meeting over the last 2 years to do revisions to DUI laws in the state of Kansas. During that review, it was pointed out that the DUI laws related to aircraft, which do exist at present, are now about 40 years old, having been initially passed in 1981. So as part of that review, we undertook to update those statutes as they now exist in Kansas statute under Chapter 3. What this does, during the conversations with the committee, had conversations with the FAA to ensure that we were coinciding with them appropriately, and they had advised through those conversations that when someone suspects an aircraft is being operated under the influence, that the person should contact local law enforcement agencies. As you might expect, FAA is not in a position to respond immediately in each of those circumstances. So in this update, the significant piece of update to the statutes involved reducing the blood alcohol level at which you are presumed to be intoxicated from 0.10 to 0.04. The remainder of the statutes were brought into compliance or in consistency with our current DUI statutes related to the operations of motor vehicles. As I said, this was brought from the Judicial Council Advisory Committee on DUI. There was the criminal defense attorneys were neutral on this bill, and the Kansas Ag Aviation Association initially was in opposition. After conversations with them, they withdrew their opposition to this particular legislation. At this point, then, I would stand for questions, Mr. Chair.
Thank you. Does any member desire to speak to the bill? The chair recognizes Representative Carmichael.
Thank you, Mr. Chair. Would the carrier of the bill stand for a question, please? Absolutely. I understand this was brought by the Advisory Committee on DUI by the Kansas Judicial Council. Do you serve on that committee?
Yes, I do.
Could you quickly explain to us how the Advisory Council and the Judicial Council works so that we can get to good legislation like this?
At the request of then Chair of the Judiciary Committee, the Speaker Pro Tem now, the Judicial Council put together the DUI Advisory Committee. The committee started its work, well, just over 2 years ago. It was made up, its membership included defense counsel from across the state, prosecutors from across the state, representative of the Department of Revenue, and several members from the judiciary here in the state of Kansas. And during the course of that time, with the information provided from outside what I'll call sources, went through the entire DUI laws in the state of Kansas in an attempt to bring them current, as well as address specific questions that may occur. We're anticipating having additional legislation proposed for this group to consider in relation to the overall DUI statutes related to automobiles, specifically with some focus on ignition interlock use at that point in time. But I do want to commend the folks who served on that committee over the 2 years, and all of the legislation that is proposed or brought resulted from consensus of the members. There were some things that we couldn't reach consensus on that didn't make it here, but that's the status at this point.
Thank you, Representative. I want you to know that the Vice Chair of the Judiciary Committee, the good representative from Dodge City, has worked tirelessly for at least 2 years now on the DUI statutes. That this is only the first, but you'll be seeing more of this hopefully within the next day or two. They have done outstanding work in bringing people together that I thought could never reach consensus. And so this is the aircraft aspect of their work. It's, as compared with other parts, it's minor, but it is an important bill, and I hope that you will join me in supporting HB 2387. Thank you, Mr. Chair.
Is there further discussion? Seeing none. Representative Ralph, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it report House Bill 2387 favorably for passage.
You've heard the motion by Representative Ralph to report House Bill 2387 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. Motion passes. Next item of business is House Bill 2214. For the purpose of carrying House Bill 2214, the chair recognizes Representative Concanon.
Thank you, Mr. Chair.
So House Bill 2214 comes out of appropriations, and it's dealing with the transfer of land from the state of Kansas to the city of Beloit. So to understand what the reason why we're doing this, I'll give you a little bit of background. In 1909, the state of Kansas purchased land from the city of Beloit to create the Girls Industrial School, which was called GIS when I was young, and those of you women old enough to remember that might have been threatened to be sent there like I was. In 1964, then, the state allowed an easement of a little over 6 acres for the water tower. There were other transfers following that are not really important to this bill. They involved the state, USD 273, the Mitchell County Fair Board, and City of Beloit. In the 2000s, the Girls Industrial School, what was the Girls Industrial School, now Beloit Juvenile Correctional Facility, closed. And the land was gifted back to the city. It's been put to great use. The Law Enforcement Center is there, Parks and Rec, a library, Early Learning Center, a community garden. But it wasn't until they were making plans to renovate the sports complex that it was discovered that this 6-acre tract of land was not included in the legal description of the land in the 2010 transfer. So the city contacted the state. They all agreed that they thought it was included. They thought it should be included. And so this piece of legislation solves that situation. So I'll stand for questions.
Any member desire to speak to the bill? The chair recognizes Representative Wolfmore.
Thank you, Mr. Chair. I don't believe I can add any more details to what was already provided, other than that all parties involved support this solution, and I urge your support. Thank you so very much.
Seeing no further discussion, Representative Cannon, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports House Bill 2214 favorably for passage.
You have heard the motion by Representative Concanon to report House Bill 2214 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next order of business is House Bill 2374. For the purpose of carrying House Bill 2374, the chair recognizes Representative Heiberger.
Thank you, Mr. Chair. I think the carrier did a fine job of explaining the bill. Oh, I'm carrying this one. Never mind.
Not yet.
But he'll do a fine job anyway. Mr. Speaker, there were no committee amendments. HB 2374 was brought to us by the Kansas Sentencing Commission. Current law requires the Sentencing Commission to make statewide supervision and placement cutoff decisions based on the risk levels and needs of offenders, and to periodically review data and make recommended changes. The statute also specifies assessment levels to be used for certain program eligibility and placement decisions. After an extensive review, the Commission recently approved the use of 2 new probation assessments, one for females and one for the male population, but the new assessments have different risk levels and scoring than the ones currently used. HB 2347 makes technical changes to the SB 123 Substance Abuse Treatment Statute and the Community Corrections Placement Statute to allow the Commission to continue to comply with its statutory charge of designating the appropriate supervision and placement cutoff levels. The only proponent was the Kansas Sentencing Commission. There are no opponents. And neither the Commission nor the Office of Judicial Administration could determine the fiscal effect of the bill, and I would stand for any questions.
Any member desire to speak to the bill? The chair recognizes Representative Jennings.
What he said.
Any further discussion? Seeing none, Representative Heiberger, you may close.
Well, as I said it in another committee earlier, plagiarism is the sincerest form of flattery. And Mr. Chairman, when the committee rises and reports, I move that it report HB 2374 favorably for passage.
You've heard the motion by Representative Heiberger to report House Bill 2374 favorably. All those in favor signify by saying aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. The next item of business is House Bill 2145. For the purpose of carrying House Bill 2145, Chair recognizes Representative Turner.
Thank you, Mr. Chair. There were no committee amendments.
Please proceed.
Thank you. Members, House Bill 2145 comes from the Utility, Energy, and Telecommunications Committee and is a bill to modify the definition of public utility to exempt electric vehicle charging stations. Current statute is the delivery or furnishing of power to be regulated by the Kansas Corporation Commission, and this bill would clarify that EV charging stations are providing a service and not power, and therefore should not be considered a public utility and therefore regulated. A similar modification was previously done to exempt compressed natural gas as used in motor vehicles. This clarification would support the expansion of EV charging stations throughout Kansas by allowing private EV charging stations to sell electricity without being classified as a regulated public utility. Proponents for this were the U.S. Army, the Citizens Utility Ratepayer Board, ChargePoint, Kansas Corporation Commission, Kansas Electric Cooperatives, Evergy, EV Build, Metropolitan Energy Center. There were no opponents, and there's no fiscal note. So with that, I am prepared to stand for questions.
Does any member desire to speak to the bill? Representative Keither.
Thank you, Mr. Chairman. I think we understand where this bill is going and what, and what it needs to be doing. This is a coming growth in car changing, and we have I-70 right going to the right middle of the United States of America. So getting involved in promoting these electric charging stations is really something we ought to get ahead of. So I am supportive of this bill and ask that you support 2145. Thank you.
Is there further discussion? Seeing none, Representative Turner, you may close.
Thank you, Mr. Chair. Mr. Chair, I move that when the committee rises and reports, that it report HB 2145 favorably for passage.
You've heard the motion by Representative Turner to report House Bill 2145 favorably. All those in favor signify by saying aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2254. For the purpose of carrying House Bill 2254, the chair recognizes Representative Ressman. House Bill 2252. My mistake. Thank you.
One of the few times I'm right. Thank you, Mr. Chair. There were committee amendments. I move the adoption of the committee report.
You've heard the motion. All those in favor of by saying aye. All opposed, no. The motion passes. You may continue.
Thank you, Mr. Chair. HB 2252 comes out of the Federal and State Affairs Committee and creates a fulfillment house license to authorize storage and shipping services provided to winery special order shipping licensees.
You'll need to speak up. Put the mic closer, please.
House Bill 2255 establishes a new fulfillment house license under the Liquor Control Act. A fulfillment house is any location or facility for in-state or out-of-state entity that handles logistics, including warehousing, packaging, order fulfillment, or shipping services on behalf of a holder of a special order shipping license. The fulfillment house would allow the license holder to warehouse, package, ship alcohol products produced by and belong to a Kansas special order shipping licensee and would apply to each location that is involved in the shipping process to Kansas residents. In the bill, for a fulfillment house license fee is $50 for each location involved in the shipping process and is valid for 2 years. The licensee would be required to make reasonable efforts to ensure winery that is being shipped is licensed in Kansas. All packages of wine shipped by a fulfillment house licensee would be required to clearly mark requiring a signature of someone 21 years of age or older and to be shipped by a common carrier. Licensee would have to maintain shipping records for 3 years and reports electronically once a month to the director of ABC. Any fulfillment house that willfully failed, neglected, or refused to report any shipments would be subject to a civil penalty of not more than $100. There was one committee amendment which reduced the fee from $100 to $50 for each location, and there was cleanup language in the bill to make the bill stronger on behalf of the ABC. There were 2 proponents, no opponents, 1 neutral, and the fiscal note in the bill brief is not correct. There is no change in the fiscal note. It still remained at $5,000. And with that, I'll stand for questions.
Any member desire to speak to the bill? The chair recognizes Representative Luis Ruiz.
Thank you, Mr. Chairman. The representative did a thorough job explaining the bill. Again, this was something that we had needed to be done for quite some time because we were losing revenue and alcohol was coming into the state with hardly any accountability. So I urge your support. Thank you, Mr. Chairman.
Any further discussion? If there is no further discussion, Representative Ressman, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports House Bill 2252 favorably for passage.
You've heard the motion by Representative Ressman to report House Bill 2252 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2238. For the purpose of carrying House Bill 2238, the chair recognizes Representative Collins.
Thank you, Mr. Chair. There are no committee amendments on House Bill 2238.
Please continue.
House Bill 2238 removes the limit of $500,000 in KSA 12-1252, and that's the amount an individual donor can give a school district or a city for the purpose of constructing and furnishing a library. This bill permits the 2 government entities to cooperate in such an endeavor. The donation limit was placed in statute in 1968. In 2021 dollars, $500,000 would be the equivalent of $799 in 1968. And there's a city in my district who is anticipating a sizable contribution for a library, and unless this is passed, they would be unable to accept that donation. And it's just, I think it's just a good bill because no one seems to know why the $500,000 limit is there, why it was put there in 1968. I've talked to people in the library business, and some of them didn't even know that this
that this limit was in the statute. And as far as proponents, the Kansas League of Municipalities, and I also testified as an opponent, and the City of Frontenac, and the Kansas Association of School Boards is a proponent. However, they only introduced written testimony. And with that, I'll stand for any questions.
Does any member desire to speak to the bill? The chair recognizes Representative Curtis.
Thank you, Mr. Chairman. Libraries are so important to all of our communities. You know, I just can't imagine living in a community that doesn't have a library. And if somebody wants to donate in excess of $500,000 for a community to build and to operate a library, I don't think we should stand in their way. So I urge your support of this legislation, and I appreciate the representative's explanation. So please vote in favor of this bill. Thank you.
Is there further discussion? The chair recognizes Representative Jacobs. I saw that he was on his way.
Thank you, Mr. Chair. Would the carrier of the bill stand for questions, please? Is this bill only constructed for individual donations?
Yes, it would lift the cap for individuals or entities.
With these particular entities, is it just Kansans, or would it be across the United States or broader across the world?
The bill does not put any specific geographical location on the entities. It could be anywhere, I guess, anywhere in the world.
My concern with this particular legislation, though, is though we all know that libraries are essential to us, it is with donations possibly from entities that are not kindly or friendly to the United States, like the CCP or the Muslim Brotherhood or Boko Haram or something like this, to bring donations to build up particular libraries with their names on it. So with that, I would just press in consideration on this bill. Thank you, Mr. Chair.
Any further discussion? Seeing none. Representative Collins, you may close.
Thank you, Mr. Chair, and I'd like to thank the representatives who had input on this. And with that, Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2238 favorably for passage.
You've heard the motion by Representative Collins to report House Bill 2238 favorably. All those in favor signify by saying aye. Aye. All opposed, no. The ayes appear to have it. The ayes do have it. The motion passes. Next item of business is House Bill 2264. For the purpose of carrying House Bill 2264, the chair recognizes Representative Humphreys.
Thank you, Mr. Chairman. There were no committee amendments. Body, I bring this to you from the Judiciary Committee. House Bill 2264 creates laws related to post-secondary school athletes and compensation for the use of student athletes' names, images, or likenesses. It permits student athletes at post-secondary educational institutions to receive compensation for the use of their name, image, or likeness. It prohibits universities and colleges from preventing that compensation. It also prohibits the schools themselves from providing compensation. and it permits athletes to have licensed or authorized agents. The bill also includes additional provisions outlining legal rights, contractual obligations, and other requirements of student athletes, athletic associations, and post-secondary education institutions. Other states are enacting similar legislation to this. Some already have, and some 35 are looking at it even during this session. So this keeps Kansas institutions on a level playing field until federal legislation is adopted. The proponents were the different Regent universities and Kansas Independent College Association, and there were no opponents. And Mr. Chairman, I now stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Carmichael.
Thank you, Mr. Chairman. Members, sit back, relax, have a little lunch. This might take a minute or two. This bill was brought to us by the athletic directors at Kansas State University and the University of Kansas. They both testified as proponents. And in addition, the president of Emporia State University testified as a proponent, but I think one could tell from her testimony that she wasn't necessarily saying that this particular bill in the form we saw it in committee was the way to deal with the problem. My characterization, not hers. Here's the problem. California, Florida, they've passed laws similar to this that say that student athletes can be compensated. They can't be compensated by the university, but they can be compensated by the alumni who hire them to work in a quote-unquote job at the car dealership. They can be compensated by Nike, who will pay them to use their names, images, or likenesses, and that's the magic nil that you might hear about, in advertising and endorsements. They can be compensated, at least under our version of this law, by the commercial gambler who wants to use their name, image, or likeness at the casino or on the online app. Why do we have to deal with this? Well, because in view of what happened in California, the NC2A has taken a look at the eligibility requirements, because I think, as all of us know, heretofore, paying student athletes under the table was not allowed by the NCAA. And so now the proposal is that we do what the University of Oklahoma has done for years and paid people under the table. By the way, the speech and debate clause gives me immunity from defaming the University of Oklahoma here on the floor, so I want to take advantage of it. But seriously, we all know that there's been phony payments from time to time even under the current NCAA eligibility rules. This new trend that didn't start in Kansas, but now it lands in our lap, is a very concerning one. Now, the NCAA is looking at making a major modification to their rules. In fact, a modification which may result conceptually in pay-to-play student athletics. The NCAA has been delayed in their consideration of that change in the rules because the United States Department of Justice has expressed to them antitrust concerns and perhaps other concerns. And so hence NCAA has not yet acted. Meanwhile, the United States Congress has bills pending before them that would enact a uniform law that would apply across the United States. Presumably, the United States Congress will spend more time deliberating and considering this legislation than we have in the House Judiciary Committee, because all we've done is listen to the two athletic directors and the president at Emporia State and reported the bill out without amendment. This bill does not contain, in my opinion, sufficient safeguards to go forward with pay-to-play student athletics. There are some restrictions that say you have to use a licensed agent if you're a student to represent you in your contract negotiations with the gamblers or the car dealer or whomever it is. There are some restrictions about whether you can enter into these agreements before the actual season starts. There are some restrictions about whether or not you can be promised this money on the side before you've signed a letter of intent. But at its core, this is hastily prepared legislation to meet the threat that California schools and Florida schools in particular might undercut K-State and KU and presumably Wichita State in recruiting efforts. An additional difficulty, which was discussed at some length with our committee by the president from Emporia State, is Title IX of the Civil Rights Act, which deals with the concept that female student athletes should have the same opportunities as male student athletes. It stands to reason that a male basketball player at Wichita State would have more endorsement opportunities at a higher rate of pay than a female basketball player at Wichita State. And I would venture to say that that is true at most institutions. In addition, I think it would be fair to assume that male revenue-producing sports like football would probably garner more financial support on the open market of advertising than sports that are not male revenue sports. And that can implicate gender bias or difference, but it can also implicate my suspicion that the curling team will not bring in nearly as much money as the basketball team. This bill does not address, in my opinion, those inequities. So the problem that we have before us is, do we want to pass legislation that is not ready for prime time because we want to make sure that the Jayhawks and the Wildcats and the Shockers have a good recruiting season? Or do we want to hope that the United States Congress will pass the appropriate law with the appropriate restrictions? Or do we want to hope that at the very least the NCAA, hopefully in coordination and cooperation with the United States Department of Justice, will come up with eligibility rules which address all of the problems that this bill creates? Now, I understand you don't want to go home to your constituents and say, you know, I cast a principled vote. I said this isn't the right way to deal with this problem, and as a result, KU didn't recruit whomever the player was because they went to Florida or California where they can get paid to play. So it's a tough vote, and I won't fault anybody who goes along with this idea. I'll just cross my fingers and hope that the United States Congress and or the NC2A acts. Of course, the problem with the NCAA acting at this point in time is if we pass this bill that doesn't contain the necessary safeguards and the NCAA passes rules that do, arguably this bill trumps those rules. The good rules, the ones that are thought out, that contain the safeguards to keep gambling out of collegiate athletics, to get equality, guarantee equality between men and women's sports, and a number of other things. But if that's not the case, if our rule trumps the NCAA, which is exactly the premise of this bill, that even though NCAA doesn't allow it now, we're going to make it legal, then whatever restrictions they might put on once they've been through careful consideration probably won't be valid in Kansas, and we may see Kansas athletes and institutions losing eligibility. But none of that's been thought through in the committee's deliberations because we only heard from 3 conferees. So as for me, I'm prepared to answer to my constituents when they say, John, why was it that you handicapped the Shockers recruiting this year? Because I'm going to tell them I thought it was the right thing to do. You make your decision on what answer you will give your constituents. So as a result, Mr. Chair, I stand in opposition to HB 2264. Thank you.
Is there further discussion? Seeing none, Representative Humphreys, you may close.
Thank you, Mr. Chairman. As the previous representative pointed out, there's a bill that has been introduced about this, and 35 other states are working on it also, and 2 other states have already passed it. So this really is about a level playing field for Kansas for now, until we get those federal things worked out. It's a stopgap until we figure out what is going to be true for every state. And until then, we should have that level playing field. So, Mr. Chairman, I move that when the committee rises and reports, it reports HB 2264 favorably for passage.
You've heard the motion by Representative Humphreys to report House Bill 2264 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. No. The ayes appear to have it. The ayes do have it. The motion passes. The next item of business is House Bill 2247. For the purpose of carrying House Bill 2247, the chair recognizes Representative Delperdang.
Thank you, Mr. Chair. There were 2 committee amendments, and just to make it open here, 3 similar bills were rolled into HB 2247. So with that, I move the adoption of the committee report.
You've heard the motion. All in favor signify by saying aye. All opposed, no. The motion passes. The committee report is adopted. Please continue.
Thank you, Mr. Chair. I'll start out with 2247 designates a portion of K67 by the Norton Correctional Facility as CO2 Trenton Brinkman Memorial Highway. That was really the first amendment because it was just to change his title on there. They had a slight error on the title. Also designates a bridge on US Highway 77 as Private First Class Lauren H. Larson Memorial Bridge. And it designates a bridge on US Highway 54 in Seward County as the Jack Taylor Memorial Bridge. And it designates a bridge on Highway 54 in Seward County as the Max Zimmerman Memorial Bridge. And then the final, the second amendment came in to put another one in here, which is designating a bridge on US Highway 166 in Cowley County as the Sergeant Tyler A. Judden Memorial Bridge. Pretty simple bill. It's all people that I think well deserve to have the bridges or highway portions named after them. So with that, I stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Potter.
Thank you, Mr. Chair. I have an amendment pertaining to memorial highways.
Amendment appears somewhat long. Would you explain, please?
Yes, the amendment would name a portion of 69 Highway a memorial highway for Senator Dennis Wilson. Senator Dennis Wilson. Okay. Senator Dennis Wilson.
Is there an objection to waiving the reading of the amendment? I see an objection. The clerk will read.
Page 2, following line 4 by inserting section 6, the portion of U.S. Highway 69 from the southern junction of United States Highway 69 with Interstate Highway 435 in Johnson County, then south on U.S. Highway 69 to the junction of U.S. Highway 69 and 135th Street, is hereby designated as the Senator Dennis Wilson Memorial Highway. Upon compliance with KSA 68-10-114 and amendments thereto, the Secretary of Transportation shall place highway signs along the highway right-of-way at proper intervals to indicate that the highway is the Senator Dennis Wilson Memorial Highway. Renumber sections accordingly. On page 1 in the title, in line 7 after bridge by designating a portion of U.S. Highway 69 as the Senator Dennis Wilson Memorial Highway.
Do you have further explanation?
I do, Chair. I first met then State Senator Dennis Wilson when I sold cars at his dealership in Paola. And anyone who knew Dennis knows he was strong-willed, had an opinion on everything, and he never shied away from telling you exactly how he felt about any issue. In addition to being a successful businessman, Dennis Wilson led a life of service to both our country and our state. He was a veteran of the United States Air Force, served as state representative from 1995 to 1999, director of governmental affairs for the state treasurer from 1999 to 2001, Johnson County treasurer from 2001 to 2004, state senator from 2004 to 2008, state lottery director from 2008 to 2009, and he sat on the board at Freedom Bank. It's my honor to offer this amendment designating a portion of U.S. Highway as Senator Dennis Wilson Memorial Highway. With that, I'll stand for questions.
Does any member wish to speak to the amendment? The chair recognizes Representative Helgerson.
You know, I hadn't heard that about Dennis. I used to call him Brush Light when he served with me here in the House. And as you might guess, we had many a spirited debate. And in some ways, it was a model friendship. Because even though we disagreed on many levels, he took me to my first and only Chiefs game. And he took me for Thanksgiving dinner with him. He was a good person, a good credit to the body that we serve here and also, well, I don't know about the Senate. I can say that because I was an ex-senator. But he was a good person that we all should support this kind of recognition for, and I'm sad that he's not here.
Any further representatives speak to the amendment? Seeing none, Representative Potter, you may close.
Thank you, Mr. Chair. I move my amendment.
You've heard the motion by Representative Potter to amend. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Back on the bill. And the chair recognizes Representative Helgerson.
As you might guess, I support the bill and recommend that you do also.
Seeing no further discussion, Representative Whose bill is it? Delperdang, you may close.
Thank you, Mr. Chair. So it looks like we've got another amendment on here, but I would view it after looking through the information and hearing the speakers as a friendly amendment. So I hope everybody will vote for this. So, Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2247 as amended favorably for passage. Thank you.
You've heard the motion by Representative Delperdang to report House Bill 2247 as amended favorably. All those in favor signify by saying aye. Aye. All opposed, no. The ayes appear to have it. The ayes do have it. The motion passes. Next order of business is House Bill 2391. The purpose of carrying 2391, the chair recognizes Representative Kessler.
Thank you, Mr. Chair. There were committee amendments. I move the adoption of the committee report.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, no. The motion passes and the committee report is adopted. Please continue.
Thank you, Mr. Chair. House Bill 2391 was brought to us by the Secretary of State Business Division. A similar bill passed by the Senate 39-0 last year, but never made it over to the House for debate. In short, this bill does several things. It clarifies definition of street addresses. It clarifies professional association abbreviations. It repeals 3 obsolete statutes from 1939 regarding blanket music laws. It allows for the acceptance of electronic signatures. It addresses UCC filings with an improperly included Social Security number. And it allows for biannual business filings starting January 1st, 2023. And it also limits the fees for reinstating business entities that did not file their annual or biannual report. There's the fiscal note on this is doesn't really anticipate any additional expenditures, and it actually may result in a reduction of expenditures by doing biannual filings instead of them having to work those filings every year. Mr. Chair, I will be prepared for questions.
Does any member desire to speak to the bill? Chair recognizes Representative Corbett.
Representative, I have a question for you. Is there anything in your bill referencing Secretary of State selling wine or beer or deer tags?
No.
Thank you. I know it's your first bill. You're an asset to this chamber, and I'm glad to see you here. Thank you.
Thank you.
The chair recognizes Representative Clayton.
Thank you, Mr. Chair. Body, this bill passed through committee without any amendments or any opposition or neutral. I urge your support. Thank you very much, Mr. Chair.
Representative Potter, did you wish to speak to the bill? Seeing no further discussion, Representative Kessler, you may close.
Thank you, Mr. Chair. I move that when the committee rises and it reports HB 2391 favorably for passage.
You've heard the motion by Representative Kessler to report House Bill 2391 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next order of business is House Bill 2128. For the purpose of carrying House Bill 2128, the chair recognizes Representative Day.
Thank you, Mr. Chair. There were committee amendments. I move the adoption of the committee report.
You have heard the motion. All in favor signify by saying aye. Opposed, no. The motion passes and the committee report is adopted. Please continue.
Thank you, Mr. Chair. HB 2128, as amended, would amend the law related to jurisdiction and supervision of participants in the non-prison sanction of placement in a certified drug abuse treatment program. The bill would provide that when a defendant is sentenced to the non-prison sanction of placement in a certified drug abuse treatment program, the district court from which the defendant is on parole, on probation, assigned to a community correctional services program, or under a suspended sentence, may transfer jurisdiction of the defendant with the concurrence of the receiving district court and all parties. If an offender is permitted to leave the judicial district of the sentencing court, the court may transfer supervision over the offender from that judicial district to another and either transfer or retain jurisdiction of the offender. The Kansas Sentencing Commission and the Kansas Community Corrections Association testified as proponents of this bill. There were no opponents. And the House Committee amended the bill to remove provisions related to participation in the certified drug abuse treatment program by non-drug offenders. The bill as amended should have no fiscal effect, and I will stand for any questions.
Does any member desire to speak to the bill? The chair recognizes Representative Jennings.
Well, it could be as simple as what she said, but that'd probably be a little bit too easy today. So I wonder if you can tell me what year Senate Bill 123 was originally passed.
Thank you, Chairman. It was 2003.
All right, good guess. Thank you so much for that information. I'm not sure I knew that. She's accurately described the contents of this bill. The title of the bill is a little misleading. It's suggested that it started out as expanding Senate Bill 123 substance abuse treatment programs to offenders who were not drug offenders. Basically, the premise was that many property crimes are committed by people with substance abuse issues. The fiscal note of that was pretty substantial, so it was amended in committee to take that out and to simply allow for this transfer of jurisdiction. And I would just like to thank the carrier and welcome you to the Corrections and Juvenile Justice Committee in the Kansas House as well.
Is there further discussion? Seeing none. Representative Day, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it report HB 2128 favorably for passage.
You've heard the motion by Representative Day to report House Bill 2128 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. Motion passes. The next item of business is House Bill 2296. For the purpose of carrying House Bill 2296, the chair recognizes Representative Hoheisel. Representative Hoheisel, are you here?
I apologize about that. Thank you, Mr. Chair. There were committee amendments. I've moved adoption of the committee report.
You've heard the motion. All in favor signify by saying aye. All opposed, no. The motion passes and the committee report is adopted. Please continue.
Thank you, Mr. Chair. Sorry, body, I was just in a little meeting back there. I don't have my notes with me, but HB 2296 would allow the Secretary of Transportation to enter an agreement with the Kansas Turnpike Authority for tolling. Part of this is for a project on Highway 69 in Overland Park. They want to basically create an express tollway on portion of Highway 69, and this HB 2296 would allow the Secretary of Transportation to enter an agreement with the Kansas Turnpike Authority to collect tolling and dispense that. And with that, I'll stand for any questions.
Okay. Does any member desire to speak to the bill? The chair recognizes Representative Helgerson.
Looks like there may be amendment coming. As the previous individual said, this gives the Kansas Turnpike Authority more leeway in tolling. You know, Turnpike this morning was great. Hardly anybody was on it. I was able to drive up in less than 2 hours. But every time I drive on the Turnpike, I keep remembering the promise that was made when the Turnpike was built. And the promise was, we're going to make it free. You know, we're going in the wrong direction in this whole thing. And this bill does encourage that. It allows the Secretary to start, instead of paying for it with our dollars, because they're going to be short in the future, we're going to have more tolling for those in the areas that can have it. Well, I don't agree with that. I still believe that the Turnpike should have been free, which was a promise that was made by legislators tens of years ago, but we've never even lived up to it, neither have any of the secretaries. You know, sometimes what we are up here doing is passing the buck to secretaries and those people in charge, and I don't think that's the way. I think if we don't have enough highways, we deal with that problem, but we don't start putting on a for-pay road because that's what Lawrence and Kansas City need. I think what we say is we're up front and we say, we have some problems financially and how do we deal with it? As opposed to say, here, Madam Secretary or Mr. Secretary, deal with the funding of this, with this program and we'll just turn it over to you. I'm sorry, I'm tired of turning keys over to anybody, and I think the bill has some real merit, but I'm not supporting it.
Further discussion, the chair recognizes Representative Neely.
Thank you, Mr. Chair. I have an amendment for HB 2296.
The amendment appears long. Would you care to explain, please?
Thank you, Mr. Chair. This amendment is an attempt to right a wrong. This amendment gives me the opportunity to do what we were voted in to do by representing the people that reside within my district. It's a condemnation case that goes back in part to 1954. In 1954, KTA took property in building and widening I-70. KTA paid for the property, and within the property was a driveway. The condemnation case was very clear that KTA was to build a new driveway that it took in the condemnation case. Unfortunately, when said driveway was built, the driveway was built on property that the landowner had no rights to. The driveway was built on KTA property. The landowner was unaware that this had occurred, and until they had purchased the property as their home and started an agricultural business, they put up a gate and a business signs to the access to the property from the road. KTA contacted the landowners demanding that the gate and the signs be removed immediately or that they would be removed. The landowners conformed to the demands, took the gate down and the signs down, Upon the landowner's contact with KTA, they were told that the issue was solved and the matter was closed. The drive was in horrible disrepair and upkeep, all but non-existent. The landowner had spent thousands and thousands of dollars in repairing the drive with an earth mover and putting new rock on the drive. Upon investigating the issue, the landowner found that the GIS photos were not even correct. Obviously, in assuming the property belonged to the landowner by the photos on record. KTA offered to build a turnaround on the KTA property several hundred yards off of the actual road to allow those that enter the property to turn around way down inside the property. This really does nothing to solve the issue of the landowners having a driveway to the road that they still would have to enter or leave by KTA property. I propose that there are three options to be considered. The first and most practical is that KTA build a driveway on the landowner's property that would adequately serve the landowner's necessity of entering and departing the property without crossing KTA property. Number two would be to survey the driveway property and it be given to the landowner in accordance to the wording within the amendment, and it be registered with the Register of Deeds in Leavenworth County. Number three would be that KTA pay the landowner to hire a contractor to build the driveway as necessary to fix the issue. I have attached this amendment to this bill because with the passing of this bill, KTA will almost certainly be doing more condemnation cases all along the different places that they decide to increase tolling. Whether it be 69 highway or K10, there'll be more condemnation cases, and I think they should fix the wrong before they create more issues. Like many other issues we have with representatives deal with on a daily basis, there was not a problem until there was a problem. I hear often how Kansas wants to be a business-friendly state, and I think we have an opportunity to actually be that here today. The landowners are good people that donated hundreds of meals to people that were struggling during the shutdown the previous year. This is a rapidly growing business that is minimal cost of fixing the issue will surely be made up in tax revenue generated by the business within a few years. We have the ability to right a wrong that can be done with minimal effort by the highly skilled workers of the KTA with their equipment and the maximum of a day or two. Thank you, and I will stand for questions to the amendment.
Are there objections to waiving the reading of the amendment? There is objection. The clerk will read.
Page 1, following line 8 by inserting new section 1A. The Kansas Turnpike Authority shall build a driveway at an agreed location on the property described in subsection B from the landowner's existing driveway to Loring Road in Leavenworth County. The driveway shall be...
The objection's been waived. Does any member wish to speak to the amendment? The chair recognizes Representative Proctor.
Thank you, Mr. Chair. Z&M Twisted Vines Winery is a small business directly affected by this amendment. This is a veteran-owned business. Brian Zessiger, one of the two owners of the business, is a retired aviator, Army aviator, with Iraq tours under his belt. Him and his wife, Gina, they bought this property understanding that it had a driveway. They wanted to use this property in order to expand their business. And as the previous speaker said, that's what Kansas is supposed to be in the business of doing, is fostering growing small businesses. That 1954 condemnation case says that KTA is supposed to build them a driveway, but despite numerous discussions with KDOT and KTA, the answer that this business owner has got is basically tough. We don't have to do it. You know, I'm a proud conservative, but I think that one thing that spreads across both aisles is that part of our job here is to protect the individual from runaway government. And so I hope that you will join me in standing in favor of this amendment to protect small business owners here in Kansas. Thank you, Mr. Chair.
For further discussion on the amendment, the chair recognizes Representative Delperdang.
Thank you, Mr. Chair. I was just looking through the bill brief on here. Permits the Secretary of Transportation to contract with Turnpike Authority to enforce toll payments and permits the Secretary of Transportation to use toll payments to support public transportation and other improvements on the toll project. But when I look at the amendment that we're talking about here, they're talking about building a driveway at an agreed location on a property described, and it gets into the details there. So I'm just trying to run these two together. So with that, Mr. Chair, I would like to challenge the germaneness of this.
Germaneness has been challenged. The Rules Committee will meet. Stand at ease. The committee will come back to order. Chair recognizes the Rules Chair.
Thank you, Mr. Chair. The committee looked at both the bill, which directs the Department of gives the Department of Transportation the ability to do things, the ability to contract with the Turnpike Authority, and the ability to use toll revenues. And then we looked at the amendment, and it directs the Department of Transportation to either build a driveway or appropriate money. So we had a couple concerns. One, we only found the one point of contact, which is the is the Turnpike Authority. And then our second concern is that this could be considered an appropriation amendment, because if the driveway is not constructed, it would require the spending of tax dollars. And because of that, we found that the amendment is not germane. Thank you, Mr. Chair.
Amendment is not germane. We are back on the bill. Representative Neely, you still have the floor.
Thank you, Mr. Chair. My point was, in making it germane, was that the KTA is going to go out and do considerable more condemnation cases involving the same thing that they're doing with this bill. Obviously, they didn't agree with that. And with that, Mr. Chair, I close on my amendment.
There is no closing on the amendment. We are back on the bill, and for further discussion, the chair recognizes Representative Tarwater.
Thank you, Mr. Speaker. Body, I agree with the first speaker on this. In 2019, we passed a bill that would allow local authorities to look at using tolls for expansion of congested highways. This was a compromise and a negotiation, one that my constituents were a little weary of after I made that vote. When we first looked at this bill, we were told that you could use the funds only to pay for the construction and maintenance of these projects. Once the project was paid for, they could stop or reduce the toll, as was indicated earlier, or increase the length of the expanded lane. We were told anyone who chose to use these lanes would pay, and anyone that did not want to pay could use the other lanes. Well, less than 2 years later, we're here again, and now we want to expand this law to use these funds for other projects and also to allow public transit to pay a lower toll or no toll at all. And I don't know about you, but if I was going to pay for a toll lane, I wouldn't want to get stuck behind a bus. Not a single project has been led on this program yet. And we all know what the bank of ks.gov has been, and that's kind of what this is doing. It's expanding that. How long before they decide to make all lanes on 69 Highway or one of your local highways toll? It's just the next logical step if you can break your promise from the original promise. The current federal administration is looking at a $2 trillion infrastructure project that will surely bring plenty of money for this project and others if it passes, and it looks like it will. There's no sense to change this before we have even used it. I cannot support this bill. Thanks for listening.
For further discussion, the chair recognizes Representative Featherston.
Thank you, Mr. Chair. Will the carrier accept a question? We accept a question? Can you clarify that this toll lane on 69 Highway, that the funds gathered, will they be used exclusively on 69 Highway and that toll lane, or can those funds be transferred to other road projects within the state?
Thank you, Representative, for that question. It's my understanding that it can only be used for projects related to the Highway 69, that corridor, or if it's for the Highway 69, that corridor, it can only spend for projects along that corridor.
Okay, thank you.
For further discussion, the chair recognizes Representative Francis.
Thank you, Mr. Chairman. I think most of you know that highways are very important to me, and I think you also know that our budget as a whole across the state always struggles to have the budgetary dollars that we need to make some of the improvements to our roads that our constituents want. I'd like to, one, answer a couple of questions. There are federal rules that will not allow the Department of Transportation to toll all of the lanes on an existing highway. What this bill will allow the Department of Transportation to do is to have what we call like hot lanes. So you're going to have some lanes that if people want to pay an additional toll, they can use to move through the area quicker. The original bill, as it was originally proposed, gave no tolling at all was required for mass transit, and we amended that bill to say that they could pay a reduced toll to use the hot lane. You know, there's only a few roads in the state that actually have the volumes necessary for any type of tolling at all. Some of the information we had was the first phase of the Highway 69 expansion, adding hot lanes, could cost as much as $300 million, and if they did the entire length that everybody wanted, it could be as much as $500 million. When the department talked to us, there was no consideration at all for this portion, for the tolling to pay for the entire project. It was only envisioned that it would pay for a portion of the project that would be decided after negotiations with the entity. I also want to mention that this bill does not refer to any special highway, any special route in any area of the state. It just gives the department an additional tool that they and the community can use to make sure a project gets done faster. I know all of you know that we've got certain projects that are laid out. For instance, all the T-Works projects have to be let before we start the new Eisenhower projects. And as those Eisenhower projects are let, it really depends upon what the availability of funds are. And so when you think about this bill, this allows all of us to get our projects done faster. So I would encourage your support of it. Thank you.
For further discussion, the chair recognizes Representative Esau.
Thank you, Mr. Chair. Body, I have mixed feelings about this bill. The previous speaker covered many of the good points. My concern is that we are allowing a toll lane that is, for the most part, going to be paid for by folks who don't live in the area, because you're not going to be hopping into that toll lane quite as quickly. So we are using non-local people to help bump up a local project so that it gets heard quickly, because it has local support, but the local funding is actually probably to the folks who live to the south of there. And that kind of troubles me, and yet at the same time, we are dealing with the fact that our tax revenue is down when it comes to fuel taxes, and somehow we have to fund our roads. And as one previous speaker also said, we've said that the toll road would go away when it was done, and it's never gone away. So sometimes I do have a bit of heartburn. As much as I love driving on the toll road and knowing that it's well maintained, it troubles me that we never kept that promise as well. So I can totally understand if you don't support this bill, and yet at the same time, I do know that it is wanted there locally in that part of the area that it's addressing on Highway 69. So I'd leave it to the will of the body how you vote on this one.
For further discussion, the chair recognizes Representative Samsel.
Thank you, Mr. Chair. I wanted to join and echo, I know that the amendment failed, the carrier of the amendment that was up here earlier, but we had a very similar problem involving another department, and so I'm very hesitant, I guess, to turn over more power perhaps from the legislature to a department, and it was where property was condemned, and then the state entered into a contract through its department with the city and the landowner, and then we, the state, through the department, did not keep our contract, which left the property owner, a small business who had moved to our city, as well as the city, in the position of not having a contract that we could enforce unless they filed a lawsuit. So similar concerns, I guess, on this bill, as I've continued to study this one and learn it. If we're getting into powers of condemnation, tolling, who gets the final say on tolling? Is that the legislature? Is that going to be the department? I understand it may be the State Finance Council or others. But so I just wanted to, I appreciated the carrier of the amendment bringing those concerns earlier. I wanted to share that those are not unique to just his part of the state. And I do hope that we can find a solution of those, even if that means a new bill or different legislation. Thank you, Mr. Chair.
For further discussion, the chair recognizes Representative Corbett.
Thank you. I'm here to kind of speak in opposition to the bill. It's simply this: Kansas ranks number 6, not for people coming in this state, but for leaving. We've got the outward migration is pretty serious. So if we got some better tax policies to make these new roads for people coming in, I'd be for it. But it seems like we're going to be building faster highways with our tax policies to drive people out. We need to kind of maybe button down a little bit, and I agree with some of the previous speakers.
Any further discussion on the bill? Seeing none. Representative Hoheisel, you may close.
Thank you, Mr. Chair. Now that I have my notes here, I just want to highlight a couple of things. I know a previous speaker said this would allow the transportation or Department of Transportation transit vehicles on this corridor in these lanes without tolls. We actually struck that portion out of the bill. They will be assessed a toll, albeit a reduced toll, if they use this lane on Highway 69. And with that, Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2296 favorable for passage. Thank you.
You've heard the motion by Representative Hoheisel to report House Bill 2296 favorably. All those in favor signify by saying aye. Aye. All opposed, no. No. The noes appear to have it. Division has been called. Clerk will open the roll and you may vote. Has every member had an opportunity to vote? Representative Ellis votes no. Representative Bourgeon votes aye. Representative Penn votes no. Representative Hubert votes no. Representative Bishop votes no. Representative Neighbor votes no. Representative Weigel votes no. Representative Keither votes no. Any further changes of vote, or any further votes? See any? Clerk will close the roll and take the tally. 50 voting in favor, 72 against. The bill fails. Our next order of business is House Bill 2270. For the purpose of carrying House Bill 2270, Chair recognizes Representative Resman.
Thank you, Mr. Chairman. There were no committee amendments. House Bill 2270 comes out of the Transportation and Public Safety budget and amends a previous budget proviso into statute. On the current law, fire insurance companies pay the Commissioner of Insurance a levy that may be equal to 1.25% to maintain the Office of Fire Marshal, the Emergency Medical Services Board, and the fire training program. HB 2270 places into statute what has been modeled into a proviso in the annual appropriations bill and determines how the levies will be distributed. The state treasurer will credit 10% of each levy to the state general fund, and those deposits should not exceed an aggregate amount of $100,000. The remainder of the deposit should be distributed in the following amounts: 64% to the state fire marshal fee fund, 20% to the emergency medical services operating fund, and 16% to the fire services training program. There were 3 proponents, no neutrals, no opponents, and there is no fiscal effect. With that, I'll stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Wago.
Thank you, Mr. Chair. The bill that the representative talked about is a good bill. I'm going to support it, and I hope you will too. Thank you for your support.
For further discussion, the chair recognizes Representative Curtis.
Thank you, Mr. Chairman. And I just have a quick question for the carrier. So in caucus, we talked about the percentages that these are moving to. So 64% for the business premiums, 20% for the Marshall Fee Fund, and then 16% for the training program. What are the percentages that these are moving from? So like what changed in that formula? I'm trying to figure out who's getting less money and who's getting more money now.
Well, yes. Right. In the original proviso, it was 0.80% to maintain the Office of Fire Marshal, 0.25% to maintain the Emergency Medical Services Board, and 0.2% to maintain the Fire Services Training Program, which equaled 1.25%.
And so the changes in the percentages of how this is allocated now was due to the funds that are needed in those? How was it determined that those percentages changed? Or what was the reasoning?
I think it was just a different way to calculate it.
For further discussion, Representative Carmichael.
Thank you, Mr. Chair. Not more than a year ago, the State Fire Marshal appeared in front of the State Rules and Regulations Board and said he was taking in more money than he needed and that he wanted to cut some fees. And of course, we all found that to be a good idea. But now I'm not clear. Is the State Fire Marshal taking more money for his operations at the expense perhaps of EMS or others, or is he taking less? And so I have a question for the carrier of the bill. Is the State Fire Marshal receiving more or less money under this bill than he is as it stands today?
He's receiving the same amount of money.
Then who is receiving more and who is receiving less? Which agencies, is EMS getting more money or are they getting less money?
No one's receiving any more or any less.
Well, I thought the bill said it's redistributing the allocation between the named groups, and I'm sorry, I just don't understand. If nobody's getting any more money, nobody's getting any less money, what are we doing here?
It's no longer a proviso, it's going to be in statute, is what we're changing.
I appreciate the carrier's explanation of that. Hopefully we won't go EFA today so that I'll have a chance to look at it in more detail before we take final action, and I appreciate your answers to my question. Okay. Thank you, Mr. Chair.
For further discussion, the chair recognizes Representative Francis.
You know, I hope by going up here I'm not complicating it any further, but what happens is the State Fire Marshal and the Emergency Medical Services Board and the KU firefighters all receive this 1.25%. The statute, as it says currently, is that the State Fire Marshal pays that whole $100,000. Because these other entities have been receiving that 0.2 and the 0.25 that the earlier representative mentioned, they have had us do a budget proviso in appropriations for a number of years, splitting that $100,000 up between the three entities based upon the percentage of the 1.25 that they receive. So all we're doing is putting in statute what has actually been done in practice through budget provisos. So anyway, that's why it's just a cleanup thing so that when somebody changes, it doesn't get dropped, honestly. Thank you.
Seeing no further discussion, Representative Resman, you may close.
Thank you, Mr. Chairman. I move when the committee rises and reports House Bill 2270 favorable for passage.
You've heard the motion by Representative Resman to report House Bill 2270 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Next order of business is House Bill 2298. For the purpose of carrying House Bill 2298, the chair recognizes Representative Bjorn.
Thank you, Mr. Chair. Thank you, Mr. Chair. There were no committee amendments.
Please proceed.
House Bill 2298 is brought by the Commerce Committee at the request of the Secretary of State. The bill clarifies existing statute for service of process on non-resident drivers. The bill gives Kansas motorists harmed by out-of-state drivers in Kansas the option of serving the out-of-state driver with legal process needed to initiate a lawsuit through a private process server. Currently, service of process can only be filed on the out-of-state driver through the Secretary of State's office. This is consistent with what other states are doing, and it allows for easier service of process. The bill also corrects an unintentional omission in law to add limited liability partnerships, LLPs, to the type of business entities subject to service of process. There were no opponents, no physical impact to the agency. There was a similar bill introduced in 2020, Senate Bill 253. It passed the Senate 39 yes, 0 no, and the House did not consider it due to early adjournment. With that, Mr. Chairman, I'm prepared to stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Clayton.
Thank you, Mr. Chair. The previous representative did a good job describing this bill. It does put us in alignment with several other states. I urge your support. Thank you, Mr. Chair.
Seeing no further discussion, Representative Bourgeon, you may close. I apologize for mispronouncing your name.
No worries. Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2298 favorable for passage.
You've heard the motion by Representative Bourgeon to report House Bill 2298 favorably. All those in favor signify by saying aye. Aye. All opposed, no. The ayes appear to have it. The ayes do have it. Motion passes. The next item of business is House Bill 2259. For the purpose of carrying House Bill 2259, the chair recognizes Representative Parker.
Thank you, Mr. Chair. There was a committee amendment. I move adoption of the committee report.
You've heard the motion. All in favor signify by saying aye. Opposed, no. The motion passes and the committee report is adopted. Please continue.
Thank you, Mr. Chair. House Bill 2259 would allow licensed providers, so physicians, PAs, APRNs, to prescribe expedited partner therapy if the patient's sexual partner is unlikely or unable to present for testing, examination, or treatment. It would require any provider who provides EPT to provide counseling and handouts as appropriate with instructions, and EPT must be prescribed within 60 days of contact. Under this bill, the Kansas Department of Health and Environment would be responsible for the administration of the act and issuing rules and regulations. As testified in committee, KDHE intends only to create rules and regulations around using EPT in the case of the sexually transmitted disease chlamydia. For clarification purposes, the bill was amended in committee to comply with current statute language in the Sync Code for minors that a child who is 16 years or older may consent to receive EPT only when no parent or guardian is available. 46 other states in the country have passed expedited partner therapy. This chamber in the Kansas House passed EPT as House Bill 2198 in 2019. House Bill 2259 will reduce the incidence and complications of untreated chlamydia. Those include sterility, pelvic infections, urethritis, ectopic pregnancy. This bill specifically helps those who are potentially, or I should say, especially helps those who are potentially in the age to have a child. And one of the benefits of treating chlamydia early is that it protects maternal health and prevents the disease from being passed on to a child. And while expedited partner therapy benefits the partner of a patient by providing treatment, it also benefits the patient themselves as the rates of reinfection sharply decline if your partner is able to be treated as well. There were many opponents for this bill, or proponents, excuse me, for this bill, including KDH&E, the Kansas Association of Local Health Departments, Kansas Association of Osteopathic Medicine, Kansas Medical Society, Kansas Pharmacists Association, and the Kansas chapter of the American College of Obstetricians and Gynecologists. There was no neutral or opposition testimony, and the fiscal note is negligible. I would stand for questions, Mr. Chair.
Does any member wish to speak to the bill? The chair recognizes Representative Ellis.
Would the Speaker answer a few questions? Thank you. I know this is a great bill. It has great and good intentions. It was told to us it was going to be in chlamydia and it would be treated by antibiotics. But reading the bill, I don't see the word chlamydia in it. And in committee, we asked the question, could it be any disease? And they said yes. Just antibiotics? No, all meds or prescriptions. Now, is that true? It could be expanded to many diseases and many prescriptions?
Thank you for the question. While it is true in statute it does not specify chlamydia in this bill, KDHE's testimony is that is the only case in which they would be prescribing rules and regulations around this. And it does not specifically carve out antibiotics. However, their intent is to create rules and regulations that are consistent with the CDC guidelines. Currently, that is what would be prescribed to treat the disease. The reason that it's open-ended is if the CDC should update those guidelines, they would not have to come back and ask this chamber to weigh in specifically.
Thank you. Now, I understand there's no limit to the partners. If someone is sick with a disease, they can have multiplicities of partners there is no limit, like 2, 3, could it be 5, 10, 15, 20? How many?
There's not a specified limit, and the reason for that is because if you cap it at one partner and there happen to be 2, then you're putting the physician in the position of having to ration who they're making that prescription to. The same would apply at 4 versus 5, 5 versus 6, wherever you would want to draw that line.
Thank you. Like I say, this is a bill with good intentions. Now, I understand reading the bill, it says it sends a warning home for pregnant women with certain prescriptions, people with allergies, but the doctor does never see the other partners. Is that true? It's all confidential?
Yes, and that's the purpose of the bill. If the doctor were already seeing the other partner, we wouldn't need this. This is to expedite the treatment of the partner who may not be able to come in for examination or treatment.
I understand that a 16-year-old with the disease can also, with no legal guardian, can also get this and treat their partners also?
Yes, that was the amendment made in committee to clarify. It brings this in line with the sync code for 16 and 17-year-olds. But again, it is in the case where a parent is not available to provide sign-off for that.
Thank you. So a stepdad could get meds for his 13-year-old daughter. A sex trafficker could get meds for his own crew. This bill does have good intentions, but I see there's a few loose ends. There's no specific diseases. There's no specific drugs. 16-year-olds can dispense drugs to their partners. No limit amount of partners. No exam of the partners. No report of the partners or allergies or dispersing of any age. All to be determined by the Secretary of Health and Environment. Now, you know, this bill has good intentions, but it has a lot of loose ends. Thank you.
For further discussion, the chair recognizes Representative Epley.
Thank you, Mr. Chair. And I want to compliment the carrier of the bill for carrying what is probably not one of the easiest bills to carry today, and I applaud him for that. He actually brought this to us on behalf of KDHE and also the Kansas chapter of ACOG, which is the American College of Obstetrics and Gynecology. I want to take a moment and explain some of the concerns raised, and they're valid concerns by the representative from just west of me. But you need to understand that once the exam door closes, there's a lot of information that takes place between the physician and the patient that I really don't think we need to wade down in the weeds and try to codify in law, and I think we need to be real careful about that. Physicians are obligated to inquire not only with the patient, but also in this case of their partners, certainly what their allergies are, and that will need to be documented. And then furthermore, what treatment is to be rendered, and that will all be documented between the physician and the patient. You know, physicians are mandatory reporters, and trust me, I've done that several times where we've reported situations for sexual trafficking, child abuse, things such as that. It's not fun, but it's part of our job, and there are many other primary responders also on that in the state. So this is important to know, and what this bill does is it actually allows us more access to learn that information and find out about those issues, as opposed to not knowing anything at this time under the status quo. So again, I'm really encouraging your support and vote on this, because this is going to allow us to gain more information about perhaps sex trafficking, God forbid, and other situations such as that. And the only way we're going to have access to that is through EPT, because I guarantee you we do not see those patients at all anymore, whereas now we'll at least have some access to them through EPT. Again, as the representative from Sedgwick pointed out, this has already been passed in 46 other states, and it's much more robust. Yes, there is some trust with KDH&E because they have told us that through statutes it will only be applied to chlamydia, and for me, that's all I need to know. It's going to be about chlamydia. If they want to expand it further, they'll have to publish that regulation. We'll have a chance to opt in or opt out on that and give input on it. That's how it works in the state of Kansas. I think this is a solid bill. I think, honestly, our state needs to catch up on expedited partner therapy, and it's time we got with 2021 on this and catch up with the 46 other states. So I'm in strong support of this as a physician. I hope you'll join me in a yes vote. Thank you.
Seeing no further discussion, Representative Parker, you may close.
Thank you, Mr. Chair. I appreciate the good words of the Vice Chair of the committee and the discussion on this. We had that discussion in the Health Committee We had a chance to offer an amendment to clarify some provisions of this and have questions answered. And so with that, I would urge your support so that we can join the other 46 states who have passed this and do this once more in this chamber as we did in 2019. So, Mr. Chair, I would move that when the committee rises and reports, it reports House Bill 2259 favorably for passage.
You've heard the motion by Representative Parker to report House Bill 2259 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. No. The ayes appear to have it. The ayes do have it. Motion passes. Next order of business is House Bill 2166. For the purpose of carrying House Bill 2166, the chair recognizes Representative Mason.
Thank you, Mr. Chairman. There were committee amendments, and I move the adoption of the committee report.
You say there are committee amendments? You've heard the motion. All those in favor signify by saying aye. All opposed, no. The motion passes. Committee report is adopted. Please continue.
Thank you, Mr. Chairman. Well, this is the one you've been waiting for, the last one of the day. This is our license plate bill. And basically, House Bill 2166 is going to add 3 distinctive license plates, whereas there would be royalty fees paid for those, and would also add military branch license plates. So the 3 royalty fee plates would be, number 1, Braden's Hope for childhood cancer license plates, number 2, the Proud Educator license plate, and third and final would be the Alpha Kappa Alpha license plates. The bill would also authorize a distinctive license plate which indicates service in an armed force, including the Army, the Navy, Marine Corps, Air Force, Coast Guard, and the new Space Force. These would be issued for passenger vehicles or trucks with a gross weight of 20,000 pounds or less, and this would be effective on January 1 of 2022 and after. So basically, that bill would allow any resident of Kansas who is a current member or an honorably discharged veteran of one of the military branches specified by the bill to apply for a distinctive license plate. Another thing the bill does is it lowers the threshold on the entry level to having a distinctive plate made. So it's going to lower the initial guaranteed minimum from 500 units to 250, and then the ongoing and any 2-year ensuing period from 250 to 125. It also reduces from 20,000 to 5,000 the maximum amount to be submitted by the sponsoring organization of a distinctive license plate, which would be paid to the division of the vehicles. The reason we're doing that is because, as many of you know, the license plates now are printed on demand digitally, and there's just not the same compulsion to have the major maximum or minimums like they have had in the past. I think that's a quick overview. With that, Mr. Chairman, I will stand for questions.
Does any member desire to speak to the bill? The chair recognizes Representative Hoheisel.
Thank you, Mr. Chair, and thank you to the representative previous for his explanation of this. I do have one quick amendment.
The amendment appears long. Would you explain, please?
Yes, sir. It does appear long, but it's rather simple. What this is doing on the military portion of the license plates, this is allowing an individual who's retired from our military to come in to the Department of Revenue, fill out their application, check a box on that application and show their DD-214, and they would be able to have retired military printed on those military tags. The initial purpose of the military tag bill when it was created this year, and I've talked to the sponsor of that original legislation, was to have retired military printed on those tags. Somewhere along the way, there was a breakdown. I had a previous amendment in committee that would just make those tags retired military tags only. That was voted down. I worked with the individuals in the committee who opposed that original amendment, as well as the Department of Revenue, and we came to this compromise. All parties are on board. The Department of Revenue is very open to this as well. So with that, I move my amendment.
Is there objection to waiving the reading of the amendment? Seeing none. Does anyone wish to speak to the amendment? The chair recognizes Representative Williams.
Thank you, Mr. Chair. And I would ask you to support this amendment that would allow individuals to do a checkoff for military, retired military. And this is a long time coming. We actually voted on it 2 years ago, and then due to some concerns, it actually was one of those votes that everybody switched on at the last minute. And so I would ask you to support this, support the retired military, and allow them the opportunity to proudly display that on their license tag. Thank you.
Any further discussion on the amendment? Representative Helgerson.
I believe this was a compromise reached by all parties in order to do the best for the retired individuals.
Seeing no further discussion on the amendment, Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close on my amendment.
You've heard the motion by Representative Hoheisel to amend. All those in favor signify by saying aye. Aye. Opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. Back on the bill. Any further discussion on the bill? Representative Reichman.
Thank you, Mr. Chair. Thank the body for having this debate. I just want you to know that Braden is one of the best neighbors a guy can have. When he was 3 years old, he was diagnosed with cancer. And 3 times he was told there wasn't a cure. He's now 16 years old. This will bring more awareness to childhood cancer, and the hope someday a kid will not hear the words, "There is no cure." So thank you.
Thank you. Any further discussion on the bill? Seeing none. Representative Mason, you may close.
Thank you, Mr. Chairman. I'd like to thank the Speaker for the words on Braden's Hope. I also want to mention the other 2 distinctive plates that will bear royalties. One of them is the Proud Educator license plate. This is a foundation that will be formed in Kansas, and its sole purpose will be to support first-year teachers and lift them up and help them out and support them. The other is Alpha Kappa Alpha, which was the first the first Greek-lettered sorority at a historic black college and university. It was founded in Howard University in 1908. So these are all worthy. The military plates speak for themselves. With that, Mr. Chairman, I move that when the committee rises and reports, it would report House Bill 2166 favorable for passage.
You've heard the motion by Representative Mason to report House Bill 2166 favorably. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The motion passes. That concludes our general orders. The chair recognizes Majority Leader.
Thank you, Mr. Chairman. I move we rise and report.
You've heard the motion to rise and report. All in favor signify by saying aye. Aye. All opposed, no. The motion passes.
Clerk will read the committee report.
Speaker, your committee of the whole recommends House Bills 2212, 2297, 2367, 2203, 2214, 2374, 2145, 2238, 2264, 2270, 2298, and Senate Bill 33 be passed. House Bills 2321, 2137, 2201, 2387, 2252, 2247, 2391, 2128, 2259, substitute for House Bill 2166 be passed as amended. House Bill 2296, motion to recommend for passage fails.
Speaker recognizes Representative Highland for motion.
Thank you, Mr. Speaker. I move the committee of the whole report.
You've heard the motion to adopt the committee of the whole report. All in favor signify by saying aye. Opposed, no. The ayes have it. The committee report is adopted. Reports of standing committees, the clerk will read.
House Bill number 2379. Committee on Transportation recommends House Bill 2379 be amended. The bill be passed as amended. Committee on K-12 Education Budget recommends House Bill 2119 be amended by substituting a new bill to be designated as substitute for House Bill number 2219 as follows. An act concerning education, relating to the instruction and financing thereof, making concerning appropriations for the Department of Education for fiscal years ending June 30, 2021 through 2023, creating the Student Empowerment Act to provide education savings accounts to certain students, requiring the student term to be conducted through in-person education and allowing for limited remote learning, requiring boards of education to allocate sufficient school district monies to improve academic performance of underachieving students, providing an alternative state aid calculation for school district remote enrollment, authorizing continuation of the 20 mil statewide property tax levy for schools and the exemption of a portion of residential property from such levy, expanding student eligibility under the tax credit for low-income student scholarship program, and the substitute bill be passed. Committee on Commerce, Labor, and Economic Development recommends House Bill 2057 be passed. Committee on Federal and State Affairs recommends House Bill 2025 be amended. The bill be passed as amended. Committee on Transportation recommends House Bill 2193 be amended. The bill be passed as amended. Committee on Transportation recommends House Bill 2245 be passed. Committee on Transportation recommends House Bill 2295 be passed. Committee on Elections recommends House Bill 2339 be amended. The bill be passed as amended. Committee on Elections recommends House Bill 2332 be amended. The bill be passed as amended. Committee on Children and Seniors recommends House Bill 2371 be amended. The bill be passed as amended. Committee on Taxation recommends House Bill 2315 be passed. Committee on Taxation recommends House Bill 2313 be passed, and because the committee is of the opinion the bill is of non-controversial nature, be placed on the consent calendar. Committee on Federal and State Affairs recommends House Bill 2340 be passed. Committee on Federal and State Affairs recommends House Bill 2138 be passed.
We'd like to return to introduction of bills. Is there objection? Seeing none, the clerk will read.
House Bill number 2426 by the Committee on Appropriations. An act concerning municipalities, authorizing municipalities to issue bonds and warrants in excess of current revenue in the case of declared emergencies, increasing the maximum allowed bond interest rate, changing the source of bond yield information.
Introduction to original motions and House resolutions. The clerk will read.
House Resolution number 6010 by Representative B. Carpenter, a resolution supporting the Future Vertical Lift Program as a part of the United States Army modernization.
Are there announcements? Representative Hoheisel. Representative Patton.
House Judiciary, we will begin meeting again at 3 o'clock on House Bill 2416. So grab something to eat, go to the restroom, and we'll see you shortly. Thank you, Mr. Speaker.
Representative Woodard.
Thank you, Mr. Speaker. Democrats, we will have agenda tomorrow, Tuesday, March 2nd at 9 a.m. Thank you, Mr. Speaker.
Representative Waymaster.
Thank you, Mr. Speaker. Appropriations Committee, we're going to be having a short meeting at the rail upon adjournment just for a bill introduction. Thank you, Mr. Speaker.
Any further announcements? The Speaker recognizes the Majority Leader for motion to adjourn.
Thank you, Mr. Speaker. Republicans, we will have calendar tomorrow morning at 9 a.m. via WebEx. Mr. Speaker, I move the House adjourn until Tuesday, March 2nd at 10 a.m.
Any further motion? All in favor signify by saying aye. Opposed, no. We are adjourned.